Okay, so we're going to switch gears now. We're going to talk about the blue question sheets. Okay, can the HOA Board of Directors reduce the number of HOA directors? The only way that you can do that is if you amend your bylaws to change the number of directors to whatever number it is that you want. So most associations have somewhere between 3 and 9 directors. Some of you, your documents will say your board has 5 members. If your documents say that, you must have 5 board members, okay? If your documents say, oh wow, great. If your documents state that you can have anywhere between 3 and 9, as long as it's an odd number, guess what? The board can choose to, increase or decrease the number of directors. You want to be careful though, because you don't want to, a board really, let's say you have 7, and let's say 3 of the directors don't like the way 4 of the other directors are handling things, right? So their solution is what? Let's make it a 3-member board. Well, you can't do that, right? So if you are going to reduce it from 7 to 3, you would have to have a board vote to do that, and your documents would have to allow you to have a board vote to do that. Okay, next question. What to do if the HOA does not have a corporation set up? Great question. What you're going to want to do is incorporate for the first time. It's a very easy document. It's form driven. Basically, the only information that you need is the names of the directors, their addresses, and how many shares your association is going to be issuing. It's very form driven. Either our firm can help you with the process, or you can do it yourself. If you want the form, call my office. We'll give it to you at no charge. You can also get the form from the Corporation Commission, and they'll give it to you. You file it with a filing fee. We suggest that you do an expedited filing because the Corporation Commission is really far behind right now in their filings. And so, thanks, Paige. And so, basically, it's a form you fill out with information about your association. You pay the filing fee, and you wait until the Corporation Commission stamps you as a corporation and gives you a number, and then you are a nonprofit corporation. So it's a very simple process. We used to have to publish the articles, which made it more difficult because you had to publish it for consecutive weeks in a local newspaper, but they took away that requirement last year, which is good. What if the HOA's directors exclude board members when discussing HOA issues over email and phone? Okay, that's bad. I know that this happens, but you have to be mindful of the fact that a quorum of the board should not be discussing association business and excluding other board members. Now, there may be times where board members disagree, but it is not appropriate or legally proper for board members to be intentionally leaving out other board members from the discussion. And that will cause a lot of dysfunction in your association if you do that. So I encourage you not to do that. Okay, may the board of directors of a planned community HOA demand that a homeowner terminate its lease with a violent tenant who has mental health issues? Okay, so we cannot make a landlord terminate a lease. That is just not one of the things that under the law, under our CC&Rs, I've never seen a set of CC&Rs that allow us to do that. What we can do is when you have a tenant that is, problematic, I think is the word I'm going to use here. And it could be anything from having wild parties to violating the association's documents, or mental health issues where you're concerned about the safety of the association. You need to open the dialogue with the landlord. And the best way to get action with the landlord is to fine them for the violations of the tenant if there's violations. So in this example, I'm guessing that we're aware of the mental health issues because there have been incidents. Maybe the police are there a lot, or maybe they've attacked somebody, or whatever the issue is. The landlord is in the business of making money, right? It's a business to them. And so if we explain to them that the violations of the tenant are going to cost them more money in the end, guess what's going to happen? They're running a business. They're going to get rid of the tenant. So short answer would be no, we can't make a landlord evict a tenant, but I know the buttons to push to get the landlord to evict the tenant. And the buttons are, just tell them, listen, this is where this is going. And usually I call the landlord when we get a file like this. And at the beginning of the call, I usually outline what the issues are, and the landlord is usually defending the tenant, right? Saying, oh, Mrs. Kravitz is really picky, right? She's next door waiting for my tenant to, rev up his motorcycle or whatever the issue is, right? And then I go through, I say, well, you're near your computer, can I send you some pictures? And then I send up the pictures of all the problems that have been happening. And then by the end of the call, I start saying, well, this is where this is going. If this behavior continues, well, first, we just fined you for this past behavior, and this is how much, you're gonna have to pay as the landlord because you're responsible. And this is where we're gonna go down the road. For every future violation, it's gonna cost this much. And then at a certain point, we're gonna file a lawsuit. And then you're gonna have to pay my legal fees, which are gonna be over $3,000. And then usually right about that point, something goes off in the landlord's head. And then they say, can I hire you to evict the tenant? Oh, okay, I just pushed the right button. And so, I think that is the way you approach the bad tenant situation, is make it hurt in the pocket of the landlord. Now, I'm not by any means saying that we should be harassing landlords. That is not what I'm saying. I'm saying when you have a bad tenant that is not following the documents, make the owner pay, and the landlord's either going to evict the person or the behavior is going to get better. Okay, is it illegal for a director to sign a neighborhood petition as a homeowner only and not as a member of the board? Good question. Yes. Just because we're on the board doesn't mean we have to recuse ourselves from any sort of a petition that's circulating around. But let me just think here for a minute, because I bet this is what happened. I bet what happened is there's a petition to remove a board member, right? And the petition to remove a board member is being circulated, and maybe this particular board member doesn't like that board member. I think what you need to decide is, of course, yes, as a board member, as a homeowner, you have a right to sign that and to get that, as a homeowner. That's one of your homeowner's rights. But I think you have to also think big picture here and think, I'm gonna have to work with this person if they don't get removed. And what sort of hard feelings is that going to cause on our board if that happens? So it's your choice. I'm just telling you, you have a right as a homeowner to sign it.
I asked that question. It wasn't that issue.
Okay.
It was a lady in a neighborhood who you know, who has been putting harassing letters on people's doors. And so another homeowner circulated a petition saying, please don't put anything on our door. And I, as a director, signed it, and I wrote after my name, homeowner. And she informed me that that was illegal, so I wanted to check.
That was not illegal. Don't you love homeowners like that? Right, that like to put those notes out to the entire community. Okay, we are having a meeting on 5/20, poolside. Our first since our annual meeting in December. There is a homeowner who almost everyone in our small community has an injunction against, and the others are just afraid of her. Any suggestions to assure our safety and a productive meeting? I'm sure you're probably not surprised to hear this, but 22 years of doing this, I've been in this situation. I've actually gone to meetings where, the pool is typically in the center of the community and you feel like a sitting duck, right? There was one in particular, I remember one meeting in particular where I was thinking, oh, I hope I don't get killed at this meeting. Okay, so a couple things, move your meeting, right? Have it at the library, have it at a local church. That would be one suggestion. Another option is hire an off-duty police officer That's very expensive and probably not a good sign to the rest of your owners. You know, if you're that concerned, have it in a more public place, you know, and if you think that this person is going to come to the meeting and make a scene, talk about it in advance. How will we handle it? So I have one of our attorneys from our firm going to a meeting tonight, another attorney who's not here, Lauren, and we strategized in our office this afternoon, it's going to be a difficult meeting. And we went through every scenario so that she would be ready tonight. And one of the scenarios was, what if the meeting gets violent? What should you do? And, you know, I said, you know, before it gets violent, step in. You know, as you see people starting to raise voices or, you know, aggressive stances, you know, stand up and say, this is a business meeting and bad behavior will not be tolerated. And if you continue, we will end the meeting. You know, and then do it, end it. I have been to lots of meetings where we have had to end the meeting because it gets out of control with bad behavior. So I hate to see that happen, but it never happens more than once. Really, truly. It's almost like you're dealing, I have little kids, so it's like once you set the ground rules, they know you mean business, and they don't try to go around you after you set the ground rules, and if they don't listen to them, then there's a punishment. The meeting's over. And so, but give a warning, you know, we want to be reasonable.
I have a question on that.
Mm-hmm.
As far as ending the meeting, would that be a motion or would that be a gavel by the president?
Really, the president has a difficult role, but the president really should just be the one that ends it. You know, you don't want to wait around, do I have a second? You know, because you kind of want to get out of there. So I would say the president needs to be in control. I've been at a meeting before where I have called the meeting because I was concerned for everybody's safety. And at a certain point, you just have to say enough and then get out of there. Nothing worse. One time I was at a meeting where we called the meeting and then everybody stayed and there ended up being like a rumble, you know, and the police came. So, I mean, it's a good time to get out of there. Let cooler heads prevail. Sometimes we'll take a break, but usually the break isn't long enough. So let people just know, okay, if this behavior continues, we don't have the meeting. The meeting's over. Yes?
If you follow Robert's Rules of Order, a motion to amend is not debatable and not amendable, so it's pretty easy to stop a meeting if you know the rules.
Right? Yes?
Should the secretary record the incident so it's a matter of record?
Yes, but do it in an unbiased way. You know, if you can. Just say that, you know, if they're state facts, you know, there was an owner, you know, there was an altercation between somebody, you know, whatever. And yes, it should be addressed because if you don't put it in the minutes, it won't be documented. And if you have to get an injunction against somebody, it'd be really nice to have the meeting minutes support what happened. A judge will look at the meeting minutes, definitely. Okay, we are a self-managed HOA and we allow rentals. Can we require renters to sign their application, to have read and understood our bylaws and our CC&Rs? Our renters are a minimum of 1 year. So can we make them sign something saying, we've read and we understand your documents? Short answer, no. Yeah. Several years ago, the legislature passed a law that says that there's only certain things we can ask a landlord regarding the rental, and it's going to be the name of the adult tenants residing in the property, the length or term of the lease. We can also ask for information if you're a 55 and over property. We can ask for age verification. You know, these are the types of things we can ask for: the vehicle identification and license plate numbers. Those are the only 4 things we can, under the law, legally require. Now, if you're asking for a copy of the lease, you can ask for that, but it's against the law. You definitely cannot make it a requirement. So best practices would be just stick with the 4 things that the law lets you do. You know, the name of the adults, the vehicle identifiers and license plate numbers, how long the lease is, and then 55 and over proof if you're a 55 and over community. Yes?
Does that mean then that the owner is responsible for giving that information to the tenant, that they understand that we're
Yes.
do we have CCNRs and bylaws that we have to live up to?
Yes. I mean, what some of my associations do is they know that the owner doesn't do it. So when the tenant moves in, they stop by with a loaf of bread, say, welcome to our community. Here are our documents. We're asking you please to comply with our documents. That's a nice way to do it. You could send a letter to the landlord saying, you know, we can only ask you for these things under the law and make it mandatory that you provide it to us, but we're requesting that you notify the tenant of our documents and give them a copy of the documents. I mean, I find the associations that are most successful on this are the ones that go out of their way and just give it to the tenant directly in a nice, welcome to our community kind of way. Because you can't count on the landlord to always do that. Okay, what are the best practices for self-managed associations to automate financial records? Is there a PC-based system best suited for HOAs? You know, it depends on how large your association is. I mean, there's all kinds of different programs that are out there. Many of the smaller associations, you know, are just using like QuickBooks to do their records. Some smaller associations, self-managed associations, you know, they're a little bit larger, might use a system like GenArc. You know, if you Google accounting systems for condominiums and HOAs, there are a number of different systems that come up. What you want is just something that's user-friendly, that can generate a P&L statement, financial statement for your association. What is the best practice for reserve fund growth? Okay, so the best practice for reserve fund growth is have a reserve study done, right? This person said, you know, should it be a percentage, like 5% or 10% of cash on hand, or 5% or 10% of our annual assessment? It shouldn't be just based on the dollars that you have or that you anticipate getting. It should be based on the long-term useful life of what your amenities are. And that's why it's really important to have a reserve study done, so that you can come in, a company can come in and give you a baseline in terms of, okay, this is the current state of your common areas, and this is how much useful life you have left in your common areas, and you know, this is how much you should be putting aside every year for the next 30 years. They give the plan to you. It's very easy. All you have to do is take the number that they give you and fit it into your budget. And if you can't fit it into your budget, maybe you have to do a special assessment to catch up, or increase your assessment rate so that you have enough money at the time that these long-term capital improvement projects come due. Okay, next question. Given the Arizona open meeting law, what are the restraints for board members being together, more than 2, outside of a meeting, if not engaging in discussions about or decisions regarding the HOA, for instance, all riding together to boot camp or other meetings? Okay, so if you're all here tonight and you're a quorum and you're not discussing your association business, but you are discussing association law, you're fine. Okay, just be careful on the way home that you don't talk about the landlord and, you know, the situation with the bad tenant, and boy, we learned something tonight. Let's vote on having Beth call the landlord tomorrow. Okay, that's where you cross the line, and then now you've violated the law. Is there a legal requirement to publish HOA election results, or is that up to each HOA? So I have mixed feelings about this. I go to a lot of annual meetings, and I'm assuming by HOA election results, I mean, of course, you want people to know who was elected, right? Obviously, you're going to post that. But are you going to shame people, right? Are you going to list how many votes they got, you know, with the intent to shame someone? I'm never in favor of that. I go to a lot of annual meetings, I read the results a lot, and I always say thank you to all the candidates for running. It was a really spirited and close election, and these are the candidates who won. That's a nice way to do it. If you want to have somebody who is angry and upset with the association, you announce to everybody, and so only got 3 votes, right? That's going to create a lot of, unrest and hard feelings. So just be mindful not to do that. It's always best to take the high road. And if you have, any busy bees that want to know, guess what they can do? They can make a records request, and they're entitled to see that information if they want to come in and see how many votes Johnny Appleseed had. Okay, is it necessary to get community input when changing the rules and regs, or is that at the board's discretion? I mean, it depends. I always think it's good to get feedback from the owners, and the best way to do that is to talk about it at an open board meeting. And if homeowners are there to listen, great, and contribute, great. If they're not, and it's not a controversial rule, then go ahead and pass the rule if your board is able to pass it with a majority vote of the board. What I'd be careful of, though, is when you have a controversial rule and you pass it at a board meeting where there's very low homeowner attendance, you're creating a hornet's nest for yourself. And it kind of goes back to the communication issue. Like, if you communicate well with your owners, you're going to get yourself out of a lot of sticky wickets, right? And so if you are communicating well with your homeowners, when a testy issue comes up, and I'm trying to think of a good one for a rule.
Escaping.
Oh, yes. Okay, so we are going to change our lush green lawns, and we are going to turn it into desert landscaping. And maybe that may not be a rule, but that is definitely going to be a testy one. I'm thinking rules more along the line of, I have a good one, a good example. So I represent a condominium association, and they passed a rule saying that anybody who wants to walk through the front lobby of their association that has a pet must pick up the pet and carry the pet through the front lobby. And there's a lot of pet owners that were not at the meeting, and that was posted in the elevators, and you would think that like World War III had erupted. Okay, I mean, this turned into a board removal petition. This turned into got on the news. And so, just think, when you're making a rule like that and there's not a lot of people at the meeting, that would be a good time to think, hey, remember when Beth said that at that seminar? This seems like this could cause some controversy. Why don't we notify the owners that we're going to be discussing this proposed rule change at the next meeting and invite them to come if they want to. And if they can't come, give them an email address where they can give their comments to us before the meeting. And that will save you a lot of headaches because it'll give you feedback in a positive way before you take the action, so then you can make a good decision based upon your constituents, because you're representing your homeowners. Ooh, what is appropriate to do as background checks or interviews of potential board candidates given our fiduciary responsibilities? Really, it's not the position of the board to background check or interview future board members. What you should do, I think, is help owners make an informed decision. So have the owners that are running for the board fill out a candidate, statement with their qualifications, what their vision is for the community. I think that's a very good idea. But bringing in owners and grilling them about, do you have a criminal record, or, But of course, that's something that would be interesting. You wouldn't want somebody, who had some financial impropriety to be the treasurer, but it's not our position, truly. Yeah, our position as the board is to help owners make an informed decision.
But when you file the Arizona Corporation Commission form, they ask if any director been convicted of a felony. So how do you find that out?
Well, you could put a box on the candidate form, and actually I have had an association member that was an association board member that we had to check that box for. So if you're concerned about that, you should have the 2 questions that are on the annual report form, which is, has the owner filed bankruptcy or any corporate entity that they were a director or officer in you could put that on there. I mean, I don't have any associations that are putting that on there, but you could. And you could also say, have you been convicted of a felony? And then they could check the box, and I guess you could put lines, explain more if yes. Okay, regarding the open meeting law, are board meetings allowed using Skype when members are apart during the summer as long as the community is notified? Do they also need to be allowed to access the meeting unless it's an emergency or an executive meeting? Really good question, because we're coming right up on summer. Okay, so under the law, all meetings of a board need to be held in Arizona. Okay, so if you are having meetings during the summertime, somebody has to be in Arizona hosting the meeting, right? And so there are times in the summertime where our office is the host, right? Our office in Phoenix. And we have directors Skyping in or conference calling in, and owners from Canada are Skyping in, calling in. There's a way to do this. So if you are going to have a regular board meeting in the summer and you don't have all your directors here, you can set up a conference line for the directors and for owners to call in, and everybody calls in at the designated time, and we have our meeting. We have our person in Arizona so that we check the box that we've met the law on that. So that is perfectly acceptable. Do we have to allow owners access to this? Yes, you do. Either they should be allowed to come to the meeting at my office, if the meeting's at my office, but also make an effort to be nice. If someone cares enough and wants to call into your meeting, give them the call-in number. Publicize it. I mean, that's another really good example of good communicators. Good communicator associations don't have problems. Okay, our bulletin boards. How long do, let's see, owner, let's see, this says, I think it says owner bulletin boards. How long for minutes board committees need to be posted? Good question. I like to keep, there's no legal answer to this, just so you know, okay? This is just my opinion. But I would say, keep it fresh. I wouldn't put a bunch of old stuff on there. As if you have a lot of space, maybe do 2 months, but keep it fresh. Maybe 1 month, and then have a statement maybe if anybody wants to see prior meeting minutes, contact the office to help you. What are your thoughts on members volunteering their time to do tasks such as front entry landscaping, painting gates, planting plants, instead of hiring contractors? Do we have, as an HOA, have a liability by doing this? Yes, I don't think it's a good idea. I think that we're running a business. We talked about that at the beginning of this program. And although, it may seem appealing to have members out there doing a cleanup day, and I would be okay with like a trash cleanup day, but anything that's going to require somebody, to actually do physical labor, if they get hurt, we have liability as the association. And so I don't think that's a good idea. Do you need to have a monthly board meeting? Our HOA is at 20 homes, and there's not much to be discussed for regular monthly board meetings. No, you don't. But check your bylaws. Most bylaws don't specify how many meetings a year you have to have, or monthly meetings or quarterly. It just says you have to have an annual meeting. Some of our boards meet monthly. Some of our boards meet quarterly. Some boards only meet twice a year. It just depends on how much business you have to conduct, and do you have enough to talk about every month? If you don't. Recently on our board, I actually suggested that we have meetings every other month, and I got a lot of pushback from my board. No, we want a meeting every month. So guess what? We're having a meeting every month. And ultimately the board decides on that unless your bylaws require something else. Okay, next question. Artificial grass. May the board make rules without amending the CC&Rs. May the brand, model, color installed be specified if you're requiring owners to put artificial grass in. Okay, so artificial grass, this is kind of a hot topic right now. For anybody who was following our legislature, there was a bill this year that did not pass, but there was a bill that said that associations could not prohibit the installation of artificial turf by owners in the planned community. So this is a hot topic, obviously with the drought. So a couple things. It's the future. If we're seeing our legislature already potentially try to pass a bill that says that artificial turf cannot be prohibited by associations, guess what? That means that there's going to be another bill next year that's going to be introduced, and they're going to continue to try to get this passed. So it's the future. So can the board make rules without amending the CC&Rs? I'd be really wary of that. I had an association in the Biltmore where they converted the front yards to artificial turf. And it was the association's responsibility to maintain, and the association paid the costs to convert the turf to artificial turf. And this was 8 years ago maybe, and it looked beautiful. It looked truly beautiful, and I'm a grass girl because I'm from Wisconsin, so I like grass, but I couldn't even tell the difference. But the owners went nuts. It resulted in a removal meeting of the board, and it really was a very divisive thing for your community. So do you have the right to pass a rule? I don't think so. That's a change to the common areas, and typically the board just can pass rules regarding the use of the common areas, typically by the owners, so the owner's use of the common areas or individual properties. I would be very wary of passing a rule mandating that artificial turf had to be used. I would never sign off on that as your attorney because I know what a nightmare that will be. If you're going to do that, or you're going to convert it from grass to desert landscaping, it's a hot topic, and you need to really discuss it. And I have one association that did a really good job on this. They're up at Scottsdale Ranch, and they actually brought in the company that was going to do the conversion, and I think they got a grant from the city of Scottsdale. Now that I think about it, the city of Scottsdale paid for half, and they explained it to their homeowners really well, and they had all these poster boards, and they had a PowerPoint, and they really knocked it out of the park. The way that they presented it, it looked better, and it was going to save the association a lot of money. So guess what? People were in favor of it. But on the flip side, if you're a board and you make this decision and people find out about it after the decision's been made and they haven't had any chance for buy-in and they haven't had any part in the discussion or vote on it, people can really they don't like that. So just keep that in mind. That's going to be a hot topic that you're going to want to talk to your owners about. Can the board, require a brand, model, color? You can, but it really should be in your CC&Rs if you're going to do that. And I really wouldn't suggest that because technology on this changes so quickly. Okay, next question. Cumulative voting. Why did the governor veto? I like this person, you're on it. Why did the governor veto the bill other than he does not want to micromanage HOAs? Okay, so this person's up. You read my website, which is good. That makes me happy. Okay, so there was a bill that was passed by our legislature this year that said that cumulative voting is prohibited. Now, cumulative voting is something that's kind of antiquated. It's in some bylaws in associations, and it says that owners, when they're voting on the election of directors, if they have 3 candidates running, they would get 3 votes on that ballot. They could accumulate all 3 for one candidate, or they could go 1-1-1, or they could go 2-1. It's very confusing. And most people, I'm counting the ballots, so most people that use cumulative voting usually don't do it right, and then I have to invalidate the ballot, which makes me sad. So anyways, so the bill was passed by the House and the Senate in Arizona saying no more cumulative voting. And Governor Ducey vetoed the bill and said, I don't think it's the place of our state and our government to be regulating voting in associations. And he vetoed it. So that's that. That's over. So if you have cumulative voting in your documents, you still can do it. Owners can still exercise their right to use it. If you are going to use it as an association, just make sure the directions are really clear so that people who are accumulating their votes do it right. Because I see so many mistakes on it that we end up invalidating half the ballots sometimes when that happens. Okay, the open meetings law. This is a great little segue right into our handout here. This person is up to speed on the new legislation. The last handout that I did not talk about is right here. It's in the packet that we gave you. And as I said, yesterday the legislature closed, and we had a very slow legislative year this year, unusually slow. You know, everybody was saying in January, oh, there's going to be like 50 HOA bills. It really didn't happen that way this year. There's really only one bill, and this person has a question on it. It's on page 5. This is the only bill that I really think is notable for us to discuss. And it talks about changes to the open meeting law. So again, this bill will go into effect 90 days from yesterday. And basically, it changes how the open meeting law is handled, absentee and mail-in ballots, and resale disclosure fees. And a lot of these things aren't really going to affect us. So, one, boards can no longer require advance notice of audio or videotaping open board meetings. There's a law that says that if an owner wants to audio tape or videotape a board meeting, they have the legal right to do so. So we can't require advance notice. Some boards wanted to know in advance, are you going to come and tape my meeting? And if they didn't tell us in advance, the board would say, you can't do it that night. We can't do that anymore under this new law. Let's see. This is kind of an interesting one. If the board elects to audio or videotape their board meeting, they can prohibit the owner from doing it. So it's a control thing. Odd, but it is kind of a control thing. So if the board wants to be in control of the audio or videotaping, the board can say the owners aren't allowed to do it that night. But then if the owners want to use it as evidence against the board in any way, the board has to give up the meeting tape. The notice of any meeting of the unit owners shall state the date, time, and place of the meeting. That seems kind of obvious. I think all of our clients are already doing that. Number 4, the notice of any annual, regular, or special meeting of the unit owners shall also state the purpose for which the meeting is called. This is new. So anytime we have an annual, regular board meeting, annual meeting, or special meeting at the board, special meeting of the owners, we have to state what the meeting's going to be about. So, you know, we have to state the purpose, including the general nature of any proposed amendment to the declaration or bylaws, any changes in assessments that require approval of the unit owners, and any proposal to remove a director or officer. So what does this mean for us? It just means when we're noticing our meetings, we're going to have to be more specific as to what we're talking about. And we're not going to be able to have things just come out of left field and vote on them at a meeting if we haven't disclosed to the members that we're going to be talking about it.
But when does this take effect? Is that
90 days from yesterday.
what?
So it's 90 days from yesterday. The governor signed it on 4/28. He did not veto it. So 90 days, count it forward from yesterday, and that will be the effective date of these bills.
So anything in the next 90 days doesn't...
You don't have to comply with this for 90 days, but 90 days, the jig is up. You got to comply with this, okay? And this is for regular board meetings, annual meetings, special meetings of the board, and special meetings of membership. So basically, anytime your board is meeting as a board, or anytime your board is meeting as a homeowners meeting, like an annual meeting or a special meeting of the members, you have to comply with this. Okay. This is a change. Before you go into executive session, you have to identify the section in the law that authorized the board to close the meeting. So remember those 5 subjects that I had up there earlier tonight? You're going to need to indicate which section of the law you're going to be discussing that night. And actually that's the law in California, that's the law in a couple other states. So you can't just say we're going into executive session. Now you need to say we're going into executive session to discuss the legal advice from our attorney. Okay. An emergency meeting of the board may be called to discuss business or take action that cannot be delayed for the 48 hours required for notice. At any emergency meeting called by the Board of Directors, the Board of Directors may act only on emergency matters. Okay, so if you have an emergency meeting, you can't go off and pick new flowers for the front entrance, okay? You have to stick to only the emergency subject. Let's see. The next one, number 7, they're really trying to bring in community managers as having some liability and some responsibility to comply with the law. So I underlined this one, just the changes in this law. So they're claiming that any person that is charged with the interpretation of these provisions, including members of the board and any community manager, shall take into account the declaration of policy and shall construe any provision of this section in favor of open meetings. So about 7 years ago, our legislature came up with this language saying, it's our intent that all meetings of the board should be open meetings, and that you can't have these work study sessions because that's a violation of the open meeting law unless you've properly noticed it. So now, the only change on this number 7 is now they're kind of pulling in the community managers. So now the managers also need to comply with this.
If you provide an agenda and supporting materials for a meeting by PowerPoint or on a website, you have to physically hand homeowners a piece of paper with that information as well?
For the agenda? You mean the agenda for the meeting?
Agendas, financial reports, supporting material.
The only thing that you have to give homeowners at the meeting is the agenda.
On a piece of paper.
Well, I suppose it's a technicality. If you have it on the screen and everybody is able to see the screen at the meeting, that should be sufficient.
So best practice would be
Best practices would be a piece of paper. Okay, and then the requirement passed by last year's legislature, we talked about this earlier, to have for any meeting of the members where you're using an absentee or mail-in ballot, to have that envelope have the name, address, and signature of the voter is repealed. So it was kind of a really crazy law last year. We talked about this, and we discussed, that why are they making us put the name, address, and signature of owners on this envelope that goes with the ballot. No one was complying with it. We had lots of discussions in our office that, like, if an owner returns the ballot properly and signs it, dates it, and has their address, a name on it, can we still count it if the ballot didn't have, or if the envelope didn't have the name, address, and signature? We left it up to the board, but it wasn't challenged, and now they've repealed it, which is good.
Now, this only applies to non-secret ballots, so it would be simple for an association just to say balloting is by secret ballot, and you can avoid that requirement, right?
For the secret ballot, you had to use a double envelope system, but there was an exception under that law last year that, if your ballot needed to be secret ballot, the ballot didn't have to have the name, address, and signature, but the outside envelope did.
Number 7, just excuse me to clarify, it says all meetings fall into the open meeting, but is that intended to mean committee meetings, let's say an architectural and landscaping committee meeting?
Any regularly scheduled committee meeting?
That's always been, that has been before.
Mm-hmm.
But if you're just having, you just notify the committee members, hey, let's get together tomorrow afternoon. And there's not a quorum of directors, it's just a committee meeting.
Mm-hmm.
Does that fall under the 48-hour notice to all the members?
Yes, if it's a regularly scheduled committee meeting.
Not regular scheduled, not regular scheduled.
Yeah, but how do you define regularly scheduled? I guess what I would say is be safe, err on the side of caution. If you have a committee that meets, it may not be regularly scheduled. You could take a hardline approach and say, okay, we have a architectural review committee, and we only meet when applications come in. It's not the first Monday of every month, it's not regularly scheduled, but should that meeting be open? I guess what I would say is, okay, they don't define what regularly scheduled means. Be safe. Why not notice it? Why wouldn't you?
Well, a lot of people don't have emails. You got to go ahead and go through the U.S. mail out notice.
Well, the great thing about the notice provisions is it can be done in any way. You can put it on your website. You can put it on a bulletin board at the association. There's lots of different ways to provide the notice. And ultimately, it's up to your board. If you don't want to notice your committee meetings, you don't have to. But if you have a homeowner that's fired up and that wants to attend them,
Sure, that's a different story.
then
I'm talking about-
they're going to potentially sue you. I haven't seen that happen since this law went into effect because everybody's kind of scratching their head wondering what's regularly scheduled. But it's a possibility, but it's a small possibility. So you have to weigh that risk as your association and decide, do we want to notice people or not? But remember, good communication, they may not even show up, but why not notify them just like you're notifying them of your regular board meetings?
What about if you want to do a property walkabout, the architectural committee or landscaping? Does that fall under that? If the architectural committee on the board decides tonight, tomorrow morning, they're going to do a walkabout with the landscaper or, do architectural inspection.
Have less than a quorum. That's the way around that. If you have a quorum of the board and you're walking around with the landscaper, it's technically a board meeting. So just have one person sign off and let the other two, members, if a quorum is 3, just have 2 walk with the person. Or notice it. Wait 48 hours and notice it. I mean, again, I don't see associations get sued for violating the open meeting law alone. Okay? I see it as a throw the kitchen sink type thing. You're getting sued for like 10 other things, and they add on. And by the way, they have meetings in secret, and they're not following the open meeting law. Very rarely in the years I've been practicing law have I seen a case that is only for, violating the open meeting law. I can't say it's never happened, but, and it's easy to prove because what the judge will say is, where are the minutes? When did this get decided? Show me the minutes. If you can't show them in the minutes, then the judge is going to assume this was done outside of the minutes. And then the judge may allow access to the board member's email. He may allow a discovery request where you can go into the individual board member's email, and you don't want that. Nobody wants it. I don't want that, right? So, okay, we have a lot of questions, so maybe let's do 10 more. And I'll stay afterwards if anybody has questions after that and answer if I didn't get to your question. Okay, can the president unilaterally postpone a regular meeting? Our bylaws say the president can call a special meeting alone. I see this from time to time. I do not think it's a good idea for the board member just to cancel a meeting. I mean, obviously, if you don't have a quorum, yes, you have to cancel the meeting, but sometimes for strategy purposes, I've seen board members will cancel a meeting because they don't have enough votes to get something passed or whatever. Don't do that. Obviously, I don't think the president should unilaterally postpone a meeting. If you don't have a quorum, that's a different thing. But a majority of the board would make the decision on, whether to postpone a meeting. How do you contest an election? First, do a records request to see if you have grounds to contest it. Get advice from an attorney and see what they say, see if they agree with you, and file a lawsuit. Write a demand letter saying that you think that what they did was wrong is another way to handle it. Go to the Arizona Department of Real Estate and file a complaint against the association. These are all different things that you can do to contest an election that you feel was improperly handled. Can you discuss the open meeting law in regards to social media and email, especially sites like Nextdoor and Facebook, where homeowners are asking questions and complaining, and board members are answering? In addition, would I be in violation for emailing the management company a question or concern and carbon copying the rest of the board? Okay, so social media does present some new challenges for all of us, right? And what I would say is, okay, answering, I see this a lot on Nextdoor more than Facebook. I mean, I think you have to decide a policy for your board. I would advise against just having random board members going on Facebook answering homeowner questions or on Nextdoor, just because they're really not speaking for the entire board. I would be okay with them going on these social media sites saying, come to the next board meeting and collectively our board will answer this question. But having somebody get into these little mini spats I've seen it on Nextdoor more than Facebook, where we've got like teaming up on the board and negative commentary, and then one board member tries to go on to defend themselves, it never ends well. So I would say just be mindful of that. It's okay to say something like maybe this story or this portrayal of the situation isn't accurate. We ask that you come to the next board meeting so you can hear more about what's actually going on. I think that's an okay answer. But trying to defend your position and getting into it with people on social media, I do not think is professional, and it's not a good idea. Do you have a cheat sheet for financial policies, procedures, and controls that you provide your associations? I do. We have one that's called How to Prevent Theft and Fraud of Association Funds. It's a cheat sheet, and it's on our website. What is the role of committees? How active should committees have in actually running the day-to-day business of associations? I mean, it just depends. It depends how much help your association needs, right? If you're really large, the large master plan communities, they have a lot of committees. And they really do help tee things up so the board can just make good decisions. They do a lot of the research. And then also in the smaller associations, right? Where we need extra help because we don't have a management company to go out and interview landscapers or whatever. So I think it just depends. The board dictates how much authority they have and how much work they do. So really you decide how the committee is structured and how much authority they have. Now, of course, the committee should never be signing contracts or hiring vendors. That should all be done by the board. May a board communicate via email as long as all board members are involved? Really good question. No. I'm sorry to say this, the only exception I can give you on this would be in emergency circumstances, but I would be giving you bad advice if I sat here tonight and said your board can conduct business via email because it is a violation of the open meeting law. I am a realist. I'm on my board, and I get copied on a lot of emails that boards are communicating about. I guess my comment is just be careful. If you're using email to make decisions, be really careful because it is probably a violation of the open meeting law. And what you may want to do is at the very next meeting, one more.
Yeah, security said we're way too far over the time.
Oh, okay, security's kicking us out. Okay, we'll make this our last question. Sure.
Like general information, like we're having our board meeting in 2 weeks, please send any, things that you want to discuss at the meeting to the management because they make generalizations. Please do that. Sort of a heads up. Like,
Well, you can exchange information like, okay, here are the bids for the tree trimming. Let's talk about it at the meeting. That's okay. But here's a contract to hire a new management company. What's your vote? Not okay.